All right, welcome everybody to Legal Aid of North Carolina's free clinic on Social Security and disability benefits. This clinic is going to explain how to apply for benefits and what to do if your application is denied. We're going to start out with Rob here going over some information, and then there will be chances to put your questions in the chat and we'll go over them at the end. Again, please, as per all of our lives, don't put any personal information or case-specific questions in the chat. This is a public forum, so people will be able to see it. We'll answer general questions at the end, but any case-specific things you will need to go ahead and call our helpline, and we'll get a case open for you that way. Without further ado, we'll let Rob take over from here.
Thanks. And feel free to ask questions along the way too, and I'll try to answer them at the end if I can't answer them in the moment. Hi, everybody. Like she said, my name is Rob Hill. I'm an attorney with Legal Aid of North Carolina. I'm based in the Greensboro office, but I mainly do Social Security work as well as Medicaid work and other types of benefits. Before we get into Social Security, I just wanted to make sure everybody's aware that we have lots of other clinics and what we do. So our areas of practice aren't limited to Social Security law or benefits. We have a great housing team, employment, education, domestic violence, consumer, bankruptcy issues. So if you have any other civil legal issues, make sure to give our central intake a call. Make sure to give our hotline a call and see if it's something we can help with. And in terms of clinics, definitely I would recommend go look at the past clinics that we've done before. There's a lot of good videos in the past on a lot of specific, really interesting stuff out there. So take a quick run through our past clinics and see if there's anything specifically addressing any other civil legal issues you might have. There's a list of what we've covered in past clinics there on your screen. Especially the Medicaid clinic lately, I think has been doing some great stuff. And the world of Medicaid in North Carolina is changing rapidly. So if you have any questions there, it'd be a great resource. Let's go ahead and dive in. So Social Security, I'm going to start. This is just a really broad overview of what Social Security is and how to apply. And I know a lot of people may think that they have a general idea of what Social Security is, but it can be surprising. It's a little bit more nuanced than some people might think. So first of all, Social Security, disability, what people may call it. There's actually two different programs. That's the first thing I want people to be aware of. Social Security disability or disability benefits, as people refer to it, can actually refer to two different things, or more than two, but two basic programs, the SSDI program and the SSI program. So they have the same medical requirements. If you are, your medical issues cause you to be disabled, you don't need to worry about which program you're going to go be put into or which program you should apply for. The medical criteria is the same. These two programs are different for financial reasons. Sorry. SSDI is an insurance type program. It's what you've seen, your FICA taxes you see on your paycheck, those go towards SSDI, the program. And so if you've worked sufficiently, if you have sufficient recent work history, then you can become eligible for the SSDI program. Whereas if you don't have enough of a recent work history, then if you are disabled, you qualify for the SSI program. Like I said, the main difference here is financial, how much you've worked in the past, and also financial in terms of how much you'll receive from the program. So the work history requirement there, they make it a little bit complicated, talking about credits of work years and everything like that. I wouldn't try too hard to try to parse exactly how many work credits you've had unless it becomes an issue later on in your process. I would just apply for both programs. And SSA, Social Security Administration, will typically be able to easily verify which program you can qualify for. But still, it's typically best to apply for both, just in case you qualify for one or the other and not the other. Generally, when I say work history, I mean something in the last 10 years of full or significant part-time work. The more you've worked, the more money you'll receive from the program if you are found medically eligible. So under SSDI, I think the average monthly benefit amount is something closer to $1,500 or maybe $1,300 or $1,200. Apologize, those numbers aren't quite right. Whereas the SSI program is a fixed amount. It's only adjusted for inflation. And so that amount, I think this year is $841, I believe, $841 a month. So that's clearly right there why you would want to be on SSDI if you're eligible for that program, because $841 a month for a lot of people is not enough to get by. So if you qualify for SSDI, definitely apply for that or investigate that. The other aspects of the financial differences, are the restrictions. The SSI program has a lot more in the way of financial restrictions on your income and your assets. So you're not going to be able to work a full-time job under either of those for two reasons. I mean, you're a disabled individual, and the whole point of this program is that you're disabled to the point where you cannot work a full-time job. But that being said, a lot of people on disability are able to work some part-time amount of work, some 1 or 2 days a job that's very low intensity or low stress. For whatever reason, their disability allows them to work a specific type of job for a limited amount of time, and so they're able to make some money. And you're able to do that under either program, but under SSI, the more you work, the more will be reduced from your benefits. Under either program, if you go over a certain amount of monthly income, you'll be held ineligible. So, and that amount this year is, I believe, $13.50. So if you're in gross wages, so if you're making more than $13.50 in gross wages, you're not going to be eligible for either program typically. And if you do make that, if you're on either program, you'll lose your eligibility. So that's the income limit to think about, and it's most important for SSI because the more you earn, the less you'll make, even if you're not hitting that $13.50 limit. And then the other thing is the asset limit. Resources is what they call it. It can be kind of confusing to get a letter in the mail, a denial saying you have too much in the way of resources. And what they mean by that are cash or things you can convert into cash. So for an individual, as you can see on your screen there, that limit is very low. Same for a couple, very, very low. They haven't increased it in, I think, decades and decades. It's $2,000. So if you have more than $2,000 in the bank, that means you will not be eligible for SSI. You could still be eligible for SSDI. Again, like I said, this is the main difference between the programs are these financial issues. But if you don't have a strong work history and you're only able to apply for SSI, you have to be aware you cannot have more than $2,000 in the bank account, but that also goes beyond the bank account. So when they say assets and resources, there's a reason why they use that term instead of the word cash. And that's because they're counting, they have a whole array, a list of countable and non-countable resources. The biggest thing that trips people up are vehicles. So they don't count your first vehicle, your primary vehicle you use to get around or go to your part-time job or what have you. They won't count that. If you have a second or a third or other vehicles, they will, and they will value that at whatever the fair market value is at the moment, of what their system tells them their fair market value is that vehicle. So a lot of people are surprised to find that they're above the asset limit for SSI or lose their eligibility for SSI and are surprised because they have maybe just one extra, a clunker in the driveway. Maybe it doesn't even work all that well, but perhaps that clunker in the driveway is worth $1,000 or $900, and you have a bank account that has another $1,000 in it or something along those lines, which isn't all that much, just enough to pay next month's rent and your extra and your clunker in the driveway. But those two things can be enough to disqualify you. So definitely be aware of the income and asset limits when you're applying for SSI and SSDI, but just be aware of the difference between these two programs as well. Okay, so another program, a third program, although it kind of falls within the SSI umbrella, is disability for children. A lot of people are not aware that there's actually disability benefits that may be available for children. The difference here is the medical aspect of things. Like I said, the difference between the other two programs, SSD and SSI, is financial. They use the same medical criteria for both when it's adults. When it comes to children, children are only going to be under the SSI umbrella, but they're also going to be analyzed differently because we'll get into this in a moment, but the analysis for adults goes into your work, your ability to work, your work history, that sort of thing. That obviously isn't applicable to children. So when children are applying, or parents are applying on behalf of their children, they're going to look at a different set of medical factors, and they're there on your screen. They're developmental areas. They categorize them as self-care, your fine motor skills, your ability to complete tasks, your learning, if you have learning disabilities or other things like that. That's what they're going to be looking for. And they're going to be heavily emphasizing school records, IEP plans, if your child has any of those, but also medical records relating to your child's development as well. I think this is a good subject for a more extensive clinic in the future. So I'm just going to leave it here for today. I just wanted people to be aware that there's three big umbrellas, I guess, of disability. When people say, I'm on or I want to apply for disability, that can mean three things. That can mean SSDI, SSI, or for children, the children SSI. And they each have different things to be aware of. So let's say you're an individual who is interested in applying for disability benefits. What's your first step? I recommend people go to the benefit eligibility screening tool on the Social Security website. There's a website there, a link there, or you can just Google SSA BEST or benefit eligibility screening tool, and just go put in some initial information. It won't; those answers aren't going to be recorded or reviewed if you decide to go forward with a full application. So definitely. Put your information in there, or information you think of another person who might be interested in applying, or however you want to use that. Just get an initial idea if you'll qualify. Okay, so let's say you've run it through the initial screening and you think, yeah, I think I might be eligible. So what is disability? Who can get disability benefits? Well, there's the legal definition, essentially a sort of simplified version of the legal definition of what disability means under SSA rules, because I think a lot of people find that the lay definition, the regular everyday definition of disabled, is a little bit different than what Social Security defines as disabled. So let's run through the definition there. So one or more, it doesn't have to be just one condition, several conditions together combined that are going to last for more than a year or are permanent until death. That's the first component. The second component, you cannot do the type of work you used to do because of this condition or conditions. So again, like I mentioned earlier, a lot of this analysis will surprise people that it's focused on your work rather than the medical issues. Medical records, medical conditions, of course, play a massive role in applying for disability, but just as much so your work history and your residual capacity to do work. So continuing on down the list, what are more severe health conditions? They're going to last for at least a year or longer. You cannot do the type of work you previously did, and you cannot do any other work, any other substantial gainful activity. As I mentioned a moment ago, it's not whether or not you can do, some 2 or 3 hour job, or 4 hour, 10 hour job a week that's very specific and things like that. It's can you do a substantial gainful employment? Can you work a job that's going to be able to allow you to live and survive on a regular basis? So those are the 3 components of what it means to be disabled. Severe conditions, going to last a while, can't do your old work, and you can't do other kinds of substantial gainful activity. So how do they actually analyze that? So confusingly, here's our 6 boxes with the 5-step sequential analysis, but this is what the judge will use, or SSA if you don't reach the level of a judge. This is how they look at a case. So if you're wondering, how will SSA look at my case when I apply? What will they be looking at? Here's the analysis that they follow. First, their first step is, are you currently engaging in SGA, substantial gainful activity? A lot of people think that refers to the number of hours you're working or something along those lines. It does not. It refers to the amount of money you're earning in the month, your gross wages. Specifically, I believe this year's gross wages, it changes based on inflation, but this year's gross wages are $1,350. So if you're making more than $1,350 per month in gross before taxes, for anything, in gross wages, then you will not be eligible for SSDI or SSI, any disability program. So that's the first step. Assuming that you are not making that amount of money, the next question is there a severe impairment or combination of impairments that will last more than 12 years? And again, I want to stress that it can be certainly a combination of impairments. So I think a lot of people think of the stereotypical idea, like lay definition of a disabled person as someone who's must rely on a wheelchair, has very severe disabilities, and that certainly are people that qualify. But it may also be others who have a combination of impairments. Perhaps your impairments are something to do with your left leg that prevents you from sitting for very long or standing for very long. But on its own may not be disabling, but in addition to that, you also suffer from severe schizophrenia or other disabling conditions that on their own might not be enough, but combined they meet they rise to the level of disability. So I think that's important to know for when you're filling out the application, when you're going through the initial application, to remember to give them all the information that you have about your medical conditions and list all of your impairments. So this next step, step 3, is, does the individual meet or equal a listing? So before they carry on with the rest of the analysis, they can stop there. SSA, Social Security, can stop there if you meet what's called a listing. A listing is exactly what it sounds like. It's a condition that's off their list of conditions. And you can actually go Google SSA listings and you'll find an honest to goodness list of various medical conditions that Social Security considers so severe that they don't need to continue on with the rest of the analysis. These are very difficult to satisfy. Very few people have conditions that are severe enough to meet a listing, especially at the initial level of applying. A double amputee would be an example, or someone with very, very, very severe schizophrenia, or chronic liver or organ failure conditions. If you review the listings, you'll see there's a whole lot of detail that goes into that. They're going to look at specific lab measurements in your blood, those sorts of things. It's a very detailed medical analysis. And even if you'll see things like on there that you may think you might satisfy, and that's a good indicator that you should apply. But don't be discouraged if you don't satisfy a listing. A lot of people that have some of the conditions that are in that list, that are on that list, don't necessarily meet a listing because it's not severe enough to rise to the level of all the very specific criteria on that list for that condition. So I think the listings are a good place marker, a good guidance for you to if you're considering, is what I have going to be considered disabling. Take a look at how they define it in the listing. And even if you don't meet that listing, it'll give you an idea of what they're looking for, what they're looking at in terms of evaluating that condition. Okay, so here's why there's a 6 box here, is because this next step is more of a 3.5 or part of the 3rd step. So assuming you don't meet a listing, the next thing they're going to do is create what they call an RFC, residual functional capacity. And it is a comprehensive assessment of exactly what that sounds like, your residual capacity to function, your remaining abilities, both exertional and non-exertional, mental and physical. And they get really detailed with that assessment. They're going to look at, they're going to get down to the level of detail of this person we believe can only sit for 2 hours out of an 8-hour day, or stand or walk for this many feet, or lift their hand this far above their shoulder. A really comprehensive assessment of your conditions, or at least it should be. And then they're going to take that remaining capacity, and then they're going to go to step 4. So given this RFC, they say he can't lift his arms this high, or the individual can't sit for more than 2 hours. Can they do their past work? So they look at, when I say past work there, I'm talking about your ability to perform any job you've done in the last 15 years. Let me see if I have a more specific slide. I should have gone to that slide next, but let's talk into a little bit. Let's talk about RFC a little bit further. So when they're looking at, can you perform any past work in the past 15 years? They're looking at your RFC. They're saying, with this RFC, can you do any of those past jobs? If you were in the warehouse, lifting heavy objects in a warehouse, well, if you can no longer lift more than 10 pounds, you cannot work in that warehouse most likely anymore, if that warehouse job included lifting more than 10 pounds. So that's at step 4, but I just want to back up here a little bit and make sure I go over what I wanted to talk about for the RFC. So digging in a little bit further on that step 3.5, what do they mean by RFC? It's right there on your screen. Exertional and non-exertional are the 2 kind of buckets of categories there. The exertional, sitting, standing, walking, lifting, carrying, pushing, and pulling. Non-exertional is more than just mental health. So a lot of people think non-exertional is mental health, and that's true. But it also includes things like your ability to manipulate objects with your fingers, your visual capacity, communicative, postural, can you stoop, can you bend over, can you climb, certain things, and also environmental. A lot of people have environmental restrictions that prevent them from doing their past or other types of work. Do you have a condition that prevents you from being in a very loud, noisy workplace? When they're assessing whether you can do jobs, they're going to need to know, are the jobs that you can do or past work, were they noisy? Then no, you cannot do those jobs. Those kinds of things. So backing up again, like I said, SGA is 1350. The severe health conditions, we've already talked about that. And then going further into this ability to work. So they're again looking at your RFC. They're also going to look at, as part of your RFC, sort of, but not the physical or mental part, is your past work, your profile. Your RFC profile will include your age, your education, and your work history. So when they're deciding, can you perform your past work, or at the next step, can you perform other jobs? What kind of education do you have? Do you have specific certifications? Are you have a license to do things like be a welder or other specific jobs like that? Also, just the general level of education you reached. And finally, your age is going to definitely be one of the most important things they consider. They significantly relax certain standards for certain age brackets. So when you reach age 50, it becomes significantly easier to be eligible for for disability benefits. When you reach 55, it again becomes even more, they relax some of the strict standards a little bit further. So your age will definitely play a big role in this. And then finally, if we've completed those last steps, you've got a severe impairment, you're not making SGA, don't meet a listing, but your RFC puts you, you don't have a very high RFC, you can't do very much. Step 4, they find you can't do your past work. Let's say all your past work was were heavy duty warehouse jobs and you can no longer lift things because something happened to your arm. So now we passed step 4. You can't do your past jobs. So then finally step 5, and this is where the burden shifts to the agency. The agency has to prove that you can't. Social Security Administration has to prove that this individual cannot do any other work in the national economy that exists in significant numbers on a substantial basis. I know there's a lot of words, kind of a word salad there. So let's dig into that a little bit further. When they say, can you perform any other jobs in the national economy? They mean, can you, like I said earlier, can you perform substantially that job? So are you going to be able to work that job, 5 days a week, 9 to 5, or whatever the job's requirements are to rise to the level of at least $1,350 a month in wages. So can you perform any of those substantial jobs? They're also going to look at, are there significant numbers of jobs in the national economy? Or they're supposed to. They're supposed to examine, okay, well, we find that this person can perform, let's say, these 3, they'll usually give certain example jobs that they think the person can perform. And they're supposed to be able to only provide jobs that actually exist in significant numbers. So they can't give, a person who sends telegrams or some other job that doesn't exist anymore. Although this is often an area of disagreement and dispute. So it's another thing to consider. Okay, so let's say you've considered that you may satisfy those steps, the analysis. How do you actually go about with the application process? So there on your screen is a whole lot of different information about how to complete the various application forms. I think that most people are most comfortable with going in person to their local field office, which you can certainly do. I would recommend just doing a quick Google for Social Security field office. I think you can put in your zip code and find the nearest one. Most major cities will have one pretty easily accessible in the downtown area. And you can call ahead to schedule a time to go in, or I believe they're accepting walk-ins now. Each office is a little bit different depending on how they're handling this stage of the pandemic. You can apply in person, over the phone. You can just call them in at that number there, do it over the phone or online. We definitely recommend, even if you don't complete the process online, at least setting up an online Social Security account, because they've really improved their online Social Security accounts. And so after you do apply, you can use that account to track the progress of your case and make sure you don't miss any important documents. Okay, so you've applied. Let's say now we're at the stage where you submitted your application, you went into the field office and you submitted all your information, you gave them the medical records you have, and you signed the authorization to allow them to request more medical records, you told them what doctors you have, all that sorts of thing, and you submit it. So then they're going to make what's called an initial decision. That's made by the DDS. It's made at the local level. As you can see there, we have some approval numbers on the side of the screen there. At the initial level, most cases are denied. 65% of cases that are received, applications that are received, are denied. And it's frustrating, but I don't want it to discourage you, because as you'll see, the allowance rates go up with each stage as the case is given more consideration. So at the next level, it's called reconsideration, where it's exactly what it sounds like. You're asking for a different independent team to reconsider, to review the information, the initial cases, the initial team's review of your case, and see if the initial team got it right or missed anything. We find that, oftentimes, not always, but oftentimes they tend to repeat what the lower stage did. You can also typically request a hearing at that stage. It's more of an informal hearing at the reconsideration level over the phone, usually with the initial caseworker, with a caseworker agent. And then finally, the third level where we typically get involved, the level where we most often get involved, is the administrative law judge stage. And so as you can see there, that's where we typically find the most success with appealing and denial at the administrative law judge stage, with 45% of cases there that were previously denied being approved. That's really, for a lot of people, going to be the first time you're able to really get in front of someone and make your case verbally, and sometimes with the help of an attorney, and after thoroughly reviewing your records, and in person, because you have the right to request an in-person hearing with the administrative law judge. So if you feel like some of your conditions maybe aren't being appreciated, the gravity of your conditions aren't being appreciated because they can't see you in person, that's going to be your opportunity to be seen in person and talk directly to a person with the power to make a decision about your case. So at that stage, after that, the appeals become somewhat more difficult to succeed on, but I'm not saying you shouldn't seek further appeal. The next stage is called the appeals council. Usually that's written arguments only, where you ask the appeals council to review the judge's decision for any legal errors or any mistakes they might have made. And then finally, the final step here is taking your case to the federal courts, essentially. So if the appeals council also denies it, then your final recourse there is to appeal it to the federal court system. It's a very difficult process, very time intensive. It takes a long time to get a decision, typically at the federal level. Not saying that people should necessarily be discouraged from it, but just that people should be aware that at that level, things become very difficult, and we definitely would recommend only trying to proceed with an attorney representation at that level. Okay, so what do they look at when they're reviewing, when that initial application is being reviewed, or your initial stages at reconsideration or the initial level? What are they looking at? So the claims examiner is what they're called there, and they're going to go through the assets, income, age, employment history, all that stuff that we talked about that should be in your application. They're going to look through your medical records. It's really important that when you're filling out your application, you list every doctor that you've been to that could possibly be relevant, or anybody you've been to in the last, several years or longer, that would have relevant information about your impairments. So make sure you have a comprehensive list of your doctors there, so that Social Security can order records from the doctor and get those records to fully evaluate your case. We're frustrated sometimes with cases where the individual had supportive documents that just didn't make it to the record at the earlier levels for whatever reason. Maybe they weren't listed or they weren't requested, but just make sure that the records you've listed them, and you can follow up with them to make sure that they've been requested. You can ask your doctor also to perform an RFC of their own. So I know I use that term. That term kind of means two things in the Social Security world. First is what I described earlier, the assessment that Social Security makes about your capacity. That considers a lot of factors, but you can also ask your doctor to complete a form, an RFC form, where the doctor provides his opinion on what your physical or mental limitations are and your remaining capacities. And that can be very helpful if you feel like your doctor would be supportive of your claim or have enough knowledge about your conditions to complete that, then definitely consider it. And then finally, we always see or often see activities of daily living that you and someone else that knows your situation can complete and submit to Social Security. And those can be pretty valuable when it comes to Social Security determining how to assess your case. And finally, one of the most important things to be aware of is that you will likely, or at least a lot of the time, claimants will be sent to speak with a consultative examiner. And that is simply an independent doctor that Social Security is paying for you to see, for the doctor to complete an analysis of your physical condition. So going to see an independent doctor, essentially. They call it a consultative examiner or a CE. And then follow up on that. And then typically the CE will complete, hopefully, a detailed, sometimes not as detailed as it should be, a detailed review of what he believes he or she believes is your medical conditions and their level of impairment. So let's say your initial claim's been denied. As we said, 65% of claims are denied at that initial level. This is where the deadlines start coming into play, and where it becomes important to keep a close watch on your mail, on documents received, the dates that they're received, and things like that, because this is where we start getting into the deadlines that a lot of people may unintentionally miss. So it's 60 days deadline to appeal here. I would try to get any appeals in at any point in time in within 10 days, usually, for several reasons. One, there's going to be a lot of deadlines to think about here, a lot of different 30-day, 60-day, 10-day deadlines. So as a default rule of thumb, it can be best to just use the lowest, the smallest deadline, and kind of use that as a guiding rod for how quickly you think you should do things, how to handle these deadlines. So a good deadline would be 10 days, but 30 days also works usually for most cases. So you have 60 days in this case to file your request for reconsideration and submit new medical records and things like that. And then let's say you get to reconsideration, the reconsideration reviewers, the claim reviewers there also affirm the denial. Again, you'll have 60 days to request a hearing before an ALJ, going to that third level that we discussed. You'll usually get a hearing notice within, this is where it gets tricky and where timelines start to really stretch out. Because you might be, the timelines are very flexible throughout this process. You may get an initial denial and a reconsideration denial within a few months of your application. I've seen other claimants wait 6 months, a year, I think in one case, to get a final reconsideration decision. So just be aware that these deadlines for Social Security and the Social Security end of things can be very flexible and it can take a long time. But when we get to the ALJ level is where things slow down even further. So you can sometimes be facing a waiting time of 12 months or longer to get to a hearing, especially if you request an in-person hearing. This is why it's best, again, to just appeal as soon as possible. And you may also consider submitting, if you're really feeling like it's best to get there as quickly as possible, you can also submit a waiver of the 75-day notice, because before you get to the hearing, they're required by law to send you a notice in advance of the hearing, 75 days in advance of the hearing, so that you have time to prepare for it. Some people elect to waive that notice so that they can get to the hearing more quickly. That's a tricky decision. It's up to everybody has their own circumstances. But those last 75 days can also be useful to make sure you have collected all the medical records you want or that you have available to prepare for the hearing, to continue seeking attorney representation, that sort of thing. And you can have the hearing by telephone, by video conferencing, and you also, of course, have an in-person hearing right, although that was delayed for the duration of the pandemic until very recently, until the last 6 months or so, they started scheduling in-person hearings again. But that's also something you have a right to. So should you get an attorney? Definitely look into an attorney, especially at the ALJ level. That's where I think advocates can be the most valuable for you. But you can certainly consider an attorney before that as well. Some people are aware of this, but not everybody, is that Social Security disability attorneys typically only collect fees out of retroactive benefit payments. So let me explain that for a moment. Retroactive benefit payments are the amount you receive dating back to when the judge or whoever decides that you are now eligible decides that you should have been eligible all along. So let's say you applied for benefits in January 1st of 2021. You got denied at the initial level, denied at reconsideration level, you filed for an appeal before they judge. And now we're finally here in September 1st of 2022. You've just had your hearing before the judge. The judge decides that actually you are disabled and that the lower level people got it wrong. Lower level analysts got it wrong. And the judge decides that you've been disabled actually since the date you applied on January 1st, 2021. Well, you'll be eligible for potentially a significant sum in retroactive benefits for those months that you should have been being paid benefits and you were not. It's a whole different topic to go into, decide, figuring out the exact amount that you'll be eligible for and those sorts of things. Very case dependent, but that's where attorneys get paid from. Social Security attorneys typically get paid out of those retroactive benefits, and it's capped at $6,000. So if you're worried about being able to pay for an attorney when you get to the ALJ level, it may somewhat assuage your concerns to know that most attorneys are only going to get paid if you're successful and only will be paid a maximum of $6,000 out of your retroactive benefits. There's other details to know there. Certain attorneys can set up alternative payment schemes and things like that, but this is the typical typical paradigm for how private attorneys practice. And we would definitely recommend you try to find an attorney at the ALJ level for several reasons. So we'll go over that now. So the ALJ hearing, again, this is your best opportunity to be approved, as you saw in the chart showing the approval rates, but also because it's the first time you're really going to be in front of someone who has the power and authority and the legal knowledge that hadn't been there before. That may not have been there before. So again, you'll want to get as much medical evidence as possible before you get to the hearing. You can continue collecting medical evidence up to 5 days before the hearing. So if you're continuing to see doctors, or you had a significant medical event happen before the hearing, but it didn't happen earlier, that's fine. Definitely include that information. Definitely submit those doctors. Make the judge aware that you have more records coming. The main thing to be aware of there is what we call the 5-day rule. You have to get all your evidence in 5 business days before the hearing. So don't wait until the very last minute. Try to get your records in as you receive them. And this is also your opportunity to submit statements from doctors on your conditions and limitations. This is also your opportunity to bring a witness to the hearing, perhaps a medical witness, but it can also be someone that you live with or someone who knows your conditions well to provide testimony about the severity of your condition, as well as vocational rehab information and training. So the location is going to be at the Office of Hearing Operations that is no more than 75 miles typically from where you live. Usually that's going to mean the Raleigh, OHO, what we call them, Office of Hearing Operations, the Raleigh OHO, the Greensboro OHO, or the Charlotte OHO, of course. It's where most people will receive their hearing. It's best to, of course, appear on time, early, and especially early now, because there's a whole lot in the way of COVID screening procedures to go through before you get to the actual hearing room. So definitely applies early, appear as early as possible, come in person, and just try to be as prepared as possible before you get to the hearing. Let's see. So at the actual hearing, when you're giving the testimony, it's always most important to be honest about your conditions, about your limitations, and avoid the concern that you need to overemphasize your conditions. Just try to give it try to give the information as plainly as possible, because sometimes we find that if an ALJ suspects that the claimant is over exaggerating on some certain aspect of their claim or some certain aspect of their conditions, that may make the ALJ call into question their credibility on other topics. So just make sure to be as honest as possible and make sure that your testimony is going to be consistent with what you've submitted in the past. So earlier I said that you can submit forms about your activities of daily living. So if in a form of activity of daily living that you submitted when you initially applied, you say that you're not able to do laundry or do dishes because of your disability, but at the hearing you say something that contradicts that can be harmful for your claim. So that's another reason why it's always important to be as honest as possible and make sure that everything you say is as consistent as possible. Your testimony will primarily be about your daily activities and your experience with your condition. I mean, you want to be prepared as possible to talk about your medical conditions and the details of your medical details. That should be on the record already in the form of the doctor's medical records that are showing those conditions exist. So your role at the hearing will be to say, yes, my medical record shows that I have XYZ diagnosis. Let me tell you about how that impacts me. Say you have fibromyalgia that's well documented in the medical records, but the medical records may not show how severely that pain is or how frequently that pain hurts you or what it limits you to doing. So be as specific as possible when you're talking about that. When you say I have pain in my legs, don't just limit it to that. Don't just say I've got shooting pain in my legs. Say only say this as it is true and applies to your conditions. But for example, you could say, instead of just saying I have pain in my legs, I have shooting pain below my kneecap that extends to my ankle and lasts for 15 minutes at a time and is typically a 7 out of 10 on the pain scale. That level of detail is most helpful for your case. Getting into the exact amount of time you think you're able to stand or sit, those kinds of exertional and non-exertional things. Getting into details if your claim is primarily about non-exertional things, mental health issues or other non-exertional issues like manipulative limitations, again, very detailed. So if your allegations include things like panic disorder or PTSD or depression, make sure to talk about how your experience, what you've experienced with that over the past several months. You can talk about how you haven't been able to go outside, or how you haven't been able to participate in daily activities you used to enjoy, those sorts of things. Get as detailed as possible there. Again, there's the medical evidence issue about 5 business days. Make sure that you get all your medical evidence submitted 5 business days for the hearing, or at least tell the judge before then that you have other outstanding records. Talk about any vocational training or your past relevant work. The past relevant work issue is very important for the testimony aspect of your past relevant work. Your past work is important at the hearing level, because it's your opportunity to talk about how that job was actually performed. So if, for example, you have something, a warehouse job on your CV, in your work history, I say the last job you did was working at a warehouse, but what you did there was more strenuous or less strenuous than what they think it might typically be. So let's say that they think that you worked at a warehouse, and under the ALJ's opinion of things, or the lower level analyst's opinion of things, maybe they think that job was something where you would have to lift only 10 pounds a day, 10 pounds at a time at a day. And you want to tell them, no, at the specific warehouse where I worked and my specific duties, I was actually lifting 30 pounds, 15 times a day, or something like that. If the job you performed is performed a little bit differently than how it's typically performed, this is your opportunity to talk about that. And that's really important for the step 4 part of the analysis about past relevant work. Talk about your medications and the side effects of those medications. That's an important aspect some people often overlook, is how severely these necessary medications are impacting your ability to work. Really make sure to talk about any prescription medical equipment you have: canes, walkers, braces. It may not be as determinative as prescription medical equipment, but it can also be helpful to talk about non-prescription medical equipment that you rely on your own time. I have had individuals in the past that have had to kind of put together their own sort of equipment in order to, without getting into too much detail, aid their ability to continue walking. That wasn't necessarily prescribed for them, but that they felt like they really depended on. Well, that was something that the judge, I believe, considered in that case. Even though it wasn't a prescription medical equipment, I think the judge validly considered that as evidence of the severity of his condition. And so on. So it goes on that way. In the same vein, daily activities, what you can do, what kind of help you need on a daily basis to get around. Again, this is your opportunity to bring a witness to talk about the severity of your condition, if you'd like. And then I don't think it's included in, I'm not sure if it's included in this set of slides, but another aspect of the ALJ hearing that makes it different from prior levels is the vocational expert. So after you've provided your testimony and the judge has asked you questions, and your attorney, if you have one, has cross-examined you, at the actual hearing, the next component of the hearing is for the judge to turn to what he calls vocational experts that'll be at that hearing with you, and ask them if, based on the testimony he's heard that day, an individual, a hypothetical, they call it a hypothetical individual with your condition, could perform their past work or could perform any other jobs. So it's exactly what he sounds like. He's a jobs expert. He's there to provide expert testimony as to his expert opinion on whether the limitations that have been discussed would prevent you from working. This is where it's most helpful to have an attorney. Cross-examining the vocational expert can be an intimidating and difficult task for some people. It can be important to accomplish, to make sure that you get questions into the VE to the vocational expert to say, okay, Mr. Vocational Expert, you said that you think I could still, or that someone could perform that kind of past work with those limitations, but what if you consider this additional limitation? Would that person still be able to do the job? That's what I mean by cross-examining the VE. And that's definitely where I think an attorney plays the biggest role or can provide the most help. So after the vocational expert provides their testimony, you can provide a closing statement, or your attorney can provide a closing statement, and that's it. These hearings usually last for an hour or less, maybe an hour and a half sometimes. There can be supplementary hearings if the judge feels like he wants to hear more testimony or get more evidence of some kind. The judge can require you to, or can request or require a new hearing, a second supplemental hearing to go over additional information. But most hearings are just that, an hour, 15 minutes of talking about your experiences with the severity of your condition. Okay, so the decision will usually arrive within 2 to 3 months after the hearing, sometimes earlier, sometimes much later, if there's certain circumstances. And it's going to be a lengthy, exhaustive written decision, or at least it should be, where the judge will go line by line through what he heard at the hearing, what he saw in the medical record, and say and render his decision about whether or not that testimony or evidence meets the various requirements to be disabled that we've been talking about. And he's going to review the medical evidence. Typically, the judge will say, I see that the claimant has these diagnoses in these medical records, but at the same time, I noticed that these records don't have that diagnosis, or think that the diagnosis is not as severe. So he will, in the decision, he or she will weigh the facts in the medical records and also weigh the testimony. They'll say in their decision, the claimant testified as to being only able to do X, Y, Z. That decision should get very detailed. And at the end of it, if he approves it, he'll also say the date of your disability began. So oftentimes that's the date you applied, or the date you set in your application when you became disabled. But it may be earlier or later, depending on the facts. Let's say you applied in January 21, and then before you got to the ALJ, you had a stroke or a heart attack or something that further reduced your capacity. It's possible the judge may say your disability started at that later date. Now, if you get a denial, you can go to the next stage of an appeal, the appeals council. Again, there's another 60-day deadline. And typically, like I said, those are going to be written appeals. Okay, so it's unfortunately not the end of the story after you've received benefits. So let's say you've gone to the hearing, the judge held in your favor, awarded you benefits, found you disabled. Well, you're going to be back in front of social, back in the system, or back considering your conditions again in just 3 years or less, because Social Security tries to conduct what they call continuing disability reviews every 3 years, and that's where they check in with you, maybe send you to a consultative examiner, an independent doctor again, and see if there's been any medical improvement to your conditions. If you've gotten any better, your conditions have been relieved, or maybe some advancement in medical technology has alleviated your conditions to the point that you can now work. So just be aware that every 3 years or so, they're going to re-review your case to see if you're still disabled. For children, they're going to get another review when they turn 18, always, because then it makes sense, of course, because they need to reassess whether that child is now disabled under the adult parameters. Remember, I talked earlier about how children are evaluated differently. So when they turn 18, they get a new reevaluation under the adult rules. And then finally, the other thing to be aware of after receiving overpayments, after receiving benefits, are overpayments. This is something that we find a lot of people encounter. So if you receive an overpayment, just know that you're not alone. There's a lot of people that get these, and they can be incurred for a lot of different reasons. Let me see if yeah. So an overpayment is most commonly occurred, at least, or one of the most common ways an overpayment is incurred is when the individual receives wages or other money that they didn't report. So Social Security is not checking on your wages necessarily every single month. They may do a review at the end of the year or after a couple of years. But you should be aware that you have a reporting obligation when you're receiving benefits. If you're able to work some part-time job, you have to report those wages. Or if you get an inheritance from a deceased relative or something along those lines, you have to report that income to Social Security. And if you don't report that income right away, or they continue paying you for whatever reason, then you could be seeing an overpayment in the future when they realize that they paid you in months that they should not have paid you. They're going to ask you to pay that back. That's an overpayment. There are a couple different ways to handle an overpayment. You can appeal it if you think they got it wrong. You can request a waiver for various reasons. ask them to waive the overpayment, acknowledging that you incurred it and it's proper, but that you can't pay it back or you shouldn't have to pay it back for various reasons. And that's, I think, a great subject for a whole other clinic, because that subject of overpayments can be quite complicated. Those are just some things to be aware of even after you receive benefits. Okay, so how can you get help? One is I definitely recommend continuing to see medical providers, of course, for your own health and healthcare improvement, but also to continue receiving doctors, because don't just rely on your own care. If you can at all, get documented care. It's really important to get these diagnoses and conditions documented, so that you're not just going to a hearing on your own, solely on your own testimony. There are 2 phone numbers there for attorneys or attorney referral services. Unfortunately, here at Legal Aid, and of course, there's our number for Legal Aid. Here at Legal Aid, we have a lot of restrictions on what kind of cases we can take. And you may be above our income limits, or other things like that may prevent us from taking your case, or we just may not have the capacity right now to take cases. We have a whole lot of cases on our docket already. So while we're here and we'd love to help, and our services are, of course, free of charge, we're not always able to. So that's why we want to make sure to include that private bar referral phone numbers. So this is a little outdated now, because Social Security offices are, for the most part, reopened now. But just be aware that a lot of local offices are still processing cases slower, or asking people to schedule an appointment in advance before coming to the field office. Excuse me. There's just more information about where to send your medical records, but most of the time you'll be asking Social Security to request the records, not sending them in yourself. Okay, and then finally, I just wanted to mention one last thing about the ACA plan, the enrollment plan, Obamacare, as it's frequently called. That's something here at Legal Aid we're able to help with. Again, of course, free of charge. And we have a great team of navigators here. That's what they're called, people to try to help navigate the Obamacare system to see if there's a plan that fits your needs, or if you're going to be eligible for subsidies that would make an Obamacare free for you or really low cost. And that's important, again, just to be able to see a doctor for your own healthcare, as well as building your record, making sure that your diagnoses are recorded. So it's been a pleasure talking with you guys today about this subject. Definitely give the navigators a look, or consider applying, and consider giving us a call if you think we'll be able to help you with anything. And there's our phone number and a few more referral lines for private bar attorneys. I should note there that cost for a consultation is just for the private attorneys. It does not cost money to call Legal Aid. All right, so let me check and see if we have any questions here.
We do have one question that came in about slide 13 about how to apply,
Sure.
if you want to pull that back up.
Yeah, let's go on back to that. Yeah, so again, a bunch of different ways. I think the field office going in person to field office can sometimes be the most satisfying for a lot of people. And most, feels like you really got to have someone hear what you needed to tell them, but also because individuals working at the field office can sometimes be helpful in reminding you about things that you want to sign or fill out. Maybe make sure that you also signed your release of records form, because Social Security, like I said, Social Security is going to want to request records from your doctors, and in order to do so, they're going to need a release from you. So when you're submitting your application, you should also submit a release for them to be able to request those. So that's some reason why some people prefer going in person, to make sure that they get all the tertiary documents completed as well. And again, make sure to make an online account if you're able to. All right, we'll give it a few more seconds here, but I'm not seeing any other questions in the chat. But just in case anybody has anything you want to ask, now's your time. I'm happy to answer anything I can. Just go back a little bit to some relevant slides. Again, there's the analysis process. What other last bits of information to leave you with? Consider, you can try to consider your own RFC when you're thinking about this. You know, what do you think is your ability for sitting, standing, walking? Don't just leave it to them. You know, be prepared to disagree with them if you think that they're not always right with their RFCs. They may ask something that is, they may decide your RFC is higher than you think it actually is. Yeah, that's right. That's right. Usually, the adult child rules that 18 to 22 age gap can be complicated. Definitely recommend taking a look on that, looking around, see if there's some online resources that can get you details. I think that's right, but I think that what it is the individual, and maybe you're wrong on this one, but I think the actual rule is that the individual can stay on child SSI until they're 22 if they're still in school. I think if you're over 18 at the time you apply, you might need to do an adult application, but that's a good question. It's a very good question. And there's little tiny details in the rules like that that can trip people up. So I think that rule only applies for if you're already on SSI when you're applying for adult if you're still in school. I'm not sure. I'll look into that. Thank you. We usually don't get a lot of 18 to 22 applications. We mostly get either children or older adults. If you've applied twice and not appealed, is the third time I'm applying going to pose extra issues? Well, yes and no. So every time you apply, you submit a new initial application. It should be reviewed as a new application, and they should look at it in that vein. They should say, okay, here's a new application with maybe new conditions or more records that weren't considered in the prior, applications. So they're supposed to give it an entirely fresh look. However, once they give it a fresh look, at the end of that, they are allowed to consider the prior decision. That's the legal language that they're kind of threading the needle there. Is even though the prior decisions aren't what we call preclusive, they're not supposed to mean that it's an open and shut case. So if you have a prior denial, it should not be an open and shut case that they deny you again. They're supposed to fully consider your new application, but they're still going to consider what the prior people decided when they're making their decision. And now, as to the other component of your question about whether you appealed it to the third level or whether you appealed it at all, that might not be a bad thing necessarily, because I think if you have an unfavorable ALJ decision on the record, so if you appealed and you went all the way up to the ALJ level, and that ALJ level wrote a really comprehensive decision outlining exactly why they don't think you're eligible for benefits, that will probably be harder to overcome than if you had not appealed and it's only the lower level decisions that denied you. But not necessarily. Another factor to consider is the length of time between your last application and your new application. If it's been several years, I think that's something that'll weigh in your favor. But no, in terms of ultimately, will it pose extra issues? No, they should take it. They should consider it in you. The only extra issue to be concerned about is they'll be looking at the past denials, and that may weigh in their decision on whether or not to deny you again. So on a new application, just make sure to stress any new developments in your conditions or increases in the severity of your conditions as opposed to whenever you applied last. All right, well, not seeing any other questions, I will go ahead and wrap up for the day. Gabby, is there anything else that you'd like to chat about before we sign off?
Nope, that covers it on my end as well. Thank you, Rob, for presenting today. Thank you, everybody that attended. This will be recorded and it's live on our Facebook now, but you can view the recording later if you want to go back and review anything that we went over now.
Great. Well, it was a pleasure talking to you guys.
Thank you, everybody. Bye-bye.